Good evening, everybody. I'm not Bill Moyers. I'm Paul Lehto, and I'm doing this presentation to kind of give an introduction to constitutional law for the purposes of explaining the kinds of claims that we have and the kinds of issues that we have here in the litigation that is otherwise known as Gail Jacobson and Lillian Ritt versus Michael Haas and Brian Bilbray, the election contest in the 50th Congressional District. Hopefully you've got a basic timeline on paper or something like that, so you know what the basic events were, and I'm going to assume that you know those things, that the election was June 6th, and that, you know, after June 6th, on June 8th, there were actually 110,000 uncounted ballots at that point in time, not the 68,500 that was reported in the press and also stated in a letter to Congress that was included in the congressional record. And then on June 13th, with at least 12,500 uncounted votes by the admission of the Registrar of Voters, and probably a lot more because we have this bump from 68,500 to 110,000, probably a lot more than 12,500, Mr. Bilbray was sworn in by the Speaker of the House. Before all the votes were counted, 16 to 17 days prior to certification or the official end of the election, the only thing that makes it official and legal, before it would even be logically possible or legally possible for any citizen to request a recount or to file an election contest or anything like that. So it was done before citizens can really exercise any legal rights with regard to the election at all. So what we have here is sort of a premature termination of the election process that is not entirely unlike Bush versus Gore in 2000, in which the court system ended the 2000 presidential election and passed or filed an order of stay, literally stopping the recount. There were actually two Bush versus Gore opinions. It's important to remember that the first one was much shorter, written by Scalia, and it stopped the recount because the Florida Supreme Court had ordered that a recount, hand recount, would take place, and the Supreme Court put an immediate stop to that. So when considering whether, you know, the American courts, you know, might actually end elections or terminate elections, it's important to remember they already have, and it was in 2000 they stopped the recount, which is an important part of the elections process. Ultimately, keeping the public from finding out that under any definition of hanging Chad or anything like that, if you counted all the votes, Al Gore won the election. The problem is Al Gore was actually asking for relief, which, if granted, would not have caused him to win the election, because he was asking for a partial recount of only, I think it was 4 or 5 counties, and that's what the Supreme Court said violated equal protection, because by giving 4 or 5 counties recount rights, so to speak, their ballots were not being treated with, quote, equal dignity, unquote, relative to the counties that did not have recount rights. And we're going to get back to Bush versus Gore and equal protection in this case, because once again the equal protection rights of the 50th Congressional District are being violated, because the early swearing in does not allow the 50th Congressional District to have a recount, but every other congressional district has one available. So in that sense, it's a classic Bush versus Gore equal protection violation, where the voters in the 50th Congressional District are all the victims. So that being, with that kind of background about the general facts, and hopefully you have a handout, although if you don't, you probably will still understand enough facts to get this. I want to start out with a few basic principles about the structure of the Constitution and about constitutional law. The Constitution is necessarily a bunch of general principles. There's no like definitions section in the Constitution. Like you normally see in statutes, they'll define all their terms and try to be particular. There's not a lot of that. There's not that kind of thing going on in the Constitution. The Constitution is intended to be general, overarching principles that are not allowed to be violated by any statutes that will be passed either by Congress or by the state legislatures. But the way that the federal government is structured is different than the way the state governments are structured, in the sense that the federal government is supposed to be a government of limited powers. In other words, the states are the original political units, and whatever rights were not granted to the federal government were retained by the states. So the states are considered in some ways, even though they're smaller, to have more broader and more general powers, whereas the federal government always has to point to some particular power in order to justify what it's doing. In modern times, they've always pointed to what's called the Commerce Clause to justify just about any kind of legislation that could be passed by the U.S. Congress. And but there are battles that go back and forth where sometimes they're very liberal in terms of what they will allow congressional power to accomplish, and then sometimes the line gets pushed back. One of the most recent times when it got pushed back is the Supreme Court invalidated a congressional law that said you can't have guns, handguns within a few hundred yards or feet of a school. They just decided that that was too much of an invasion of a state's prerogative. States could do that, but the federal government could not. But anyway, the general principle is that the federal government has limited powers. The purpose of elections was pretty much agreed upon by all of the founders, whether you're talking about the more liberal founders or the more conservative founders, and that they considered it to be the main bulwark of the people against the possibility of oppressive government. So even if you're talking about Adams, who was a little wary and said so about the idea of quote-unquote democracy, he still thought and was very much in favor of elections. Democracy, they thought, was something where you would have direct rule, as opposed to where you elect representatives, and those representatives then go to Washington, D.C. or to the Capitol and represent. That's either called representative democracy or kind of a republic format. So sometimes you have this debate where people say, well, we don't really have a democracy, we have a republic. But what they're really talking about really is representative democracy for the most part. So when we say democracy, we're not necessarily talking about direct rule or vote by every person on every single issue, but rather electing representatives. But despite that debate, if anybody ever talks about, this is not a democracy, this is a republic, all of the founders agreed, and it's important not to get sidetracked with that objection, which comes up from time to time, because everybody agreed that elections are the #1 protection of the people against government oppression, and they're also the way for the people to sort of change the direction of government, kind of like the steering wheel of society. So if you don't have elections, I oftentimes compare that to driving blindfolded without a steering wheel. You really can't change the direction of government, and you're just careening out of control, and there's really nothing that you can do about it. Another way that I, the tentative title of a book that I'm writing is that when the people don't have that kind of control, the government sort of stays stuck on stupid. So that's a possible title of the book, is Stuck on Stupid, because how are you going to change the government if you don't have elections? It's just going to stay stupid, and there's, it's not going to get off that point in terms of the perspective of, we the people. Now, there's also a structure to elections, because you've got the feds and you've got the states. And there are both federal elections and state elections, and they're kind of like parallel and separate tracks. Now, the states could all have completely separate state and federal elections. In other words, the elections for president, senator, and House of Representatives could be on they're right now in November. They could be on just on that date, and there could be no other races on the ballot. It could just be a federal election. Right now, no states are doing that. But legally, both federal and state elections are constitutionally separate. The states get to completely run state elections, and the feds, through the Constitution and statutes, can regulate the federal elections. So we also have this Help America Vote Act, which most people have heard about, which funds voting machines and stuff like that, and it literally says it only applies to federal elections. So it's always within the power of the states to decide, if they would choose to do so, that we're not going to have, you know, combined federal and state elections anymore. We're going to have separate elections. We're going to have different voting machines or voting methods for the state elections. No state has currently done that because they like all the money that is saved by having the elections at the same time. But potentially a state could choose to strike off and just have separate state and federal elections because they are constitutionally separate, and neither the states are not supposed to interfere with federal elections, and the federal elections are not supposed to interfere with, or the feds are not supposed to interfere with the state elections. But again, for practical reasons, they oftentimes go together. So that's why when HAVA says we're going to do this and we're going to do that, it tends to call the shots over all elections, because no state wants to go ahead and fund, you know, the voting machines separately or some other system separately for state elections. So the states are considered to be sister sovereign authorities. They're like, in a sense, they're almost at the same level as the federal government. They're like, you know, two separate countries next to each other. At least there's a very strong state sovereignty with respect to elections, much stronger than the states' rights arguments would be in the area of, you know, the Commerce Clause or some other area. The states' rights arguments would be weaker than they would be under elections. Because the states, remember, the colonies started out as separate and they came together. So they had elections before the Constitution, and those are supposed to somehow stay separate. So once we understand, you know, that we've got these parallel elections, federal and state, you know, the feds are supposed to have limited powers. They're only supposed to regulate the federal elections. Now we're ready to finally, you know, start out with what we're really talking about in this case. The defendants are saying under Article 1, Section 5, that's called the Qualifications Clause, that each house shall be the judge of the elections, returns, and qualifications of its own members. That has been held with some courts to create something called an exclusive jurisdiction, meaning that no court, for example, could say, you know, interfere with or order the House of Representatives to unseat a representative and to put somebody else in the middle of the term or something like that. What we're dealing with in this case is to compare Article 1, Section 5 to Article 1, Section 4, which comes right before that. And Article 1, Section 4 says that the states will regulate the time, place, and manner of federal elections. So even though you've got these parallel tracks, you've got federal elections and state elections, the Constitution says states, you get to run the federal elections. And you get to decide the time, place, and manner of the federal elections. So now we've got the states running the whole show. I mean, there aren't any federal elections officials that collect ballots or that, you know, have people sign poll books or something. Those are all state officials or state volunteers. They're all state, not federal. You know, there are some federal, you know, the Election Assistance Commission and stuff like that. But you don't have a whole separate machinery coming from the feds. Again, the states are kind of running everything. So with regard to federal elections, you know, the states control the time, place, and manner unless Congress specifically overrides that. So if Congress makes a specific statute, it's, you know, then that's going to call the shots. But if Congress hasn't said something specifically on point with regard to federal elections, then the state rule is going to apply. So we've got a situation where you have an election on June 6th, and the state is running the whole show, or the County of San Diego. Michael Haas, Registrar of Voters. They're running the whole show as to both the state races, the county races, and the federal races. And during that, you know, as we're coming up to June 6th, let's pretend that, you know, it's now June 4th or June 5th. The election is going to be tomorrow. Based on Article 1, Section 4 and 5, we would expect that the state is going to count the votes for Congress, and we would also expect that the state is going to recount the votes for Congress. It's all part of the time, place, and manner of elections. There is no, you know, regular procedure for states to recount, or for the feds to do the recount as a regular course. So The 1972 Supreme Court case of Rauterbusch versus Hartke says pretty much exactly this, that because the states have jurisdiction to do the counts, presumably they have jurisdiction to do the recounts. And therefore, the Supreme Court held in 1972 that Indiana did have the right to do a recount in a Senate race. And the Senate would have provisions very, very similar to the House's provisions under Article 1, Section 5. Or actually, that is the same provision because it says each House, meaning both the House and the Senate, shall be the judge of elections, returns, and qualifications. So because prior to the election, we would expect that states can do recounts, and that's been the typical practice. When we have this early swearing in that is argued to have the effect of stripping the state of the ability to do any recount, that constitutes a change from what we would have expected on June 5th. And that is another one of the holdings of Bush versus Gore and the really strong arguments that the Republicans were banging the table with in 2000, is you can't change the rules after the election. The recount rules were changed after the election. There's no longer a recount right according to the jurisdictional argument that was made by the defendants and accepted by the judge. So we already have the fact that the jurisdictional argument that was made by the judge violates equal protection because it denies recount rights to the 50th Congressional District and doesn't deny recount rights to other congressional districts. Now we have another type of violation, and that is changing rules after the fact. You know, that's also going to be an equal protection violation, or another way to see the violation that's going on here. So, but they do in fact go in and they swear in Bilbray. It is purported to be unconditional, you know, so they're not waiting for anything else to occur. And then they argue on August 22nd in their briefs that the exclusive jurisdiction under Article 1, Section 5 has been triggered, that nobody, and most especially the court, the Superior Court in San Diego, has any power whatsoever to do anything with regard to the election, because now the sole power to deal with it, the sole power to judge, to consider, to recount, and everything like that has been transferred to the House of Representatives as of that point. So, given the way the Article 1, Section 5 normally would operate, you know, there is a basic operation of Article 1, Section 5 that would be relatively non-controversial, and that would be if somebody was sworn in after certification, a proper election, and there's no contest, then after that point, there should not be any longer any interference or role for the states. At that point, it has transferred over to exclusively federal. But here, there's something in this case that is very, very different from the authorities that were cited by the defendants. Because in this case, unlike the written precedents that they were citing, we were specifically asking the court to review the constitutionality of the early swearing in of Bilbray. We were attacking that event as being improper. As in all of the other cases, the swearing in is the swearing in, and it was undisputed at that point in time, whereas we're attacking the constitutionality of the swearing in itself as being improper. The reason the defendants, in my opinion, styled this case as a jurisdictional argument is because that frame or that framework favors them. But really, what it's all about is whether or not the early swearing in is valid. Because if it is valid, then they can swear in Bilbray 5 days after the election, 1 day after the election, and they can swear him in a week before the election ever takes place, because it's an absolute power, so there's no limit on him. So the problem, and the additional problem with the defendant's argument is that they are creating, or they've created a species of what you would call absolute power, which is like the number one thing that the founders were absolutely against, because they had absolutely dealt with absolute power. The king can do no wrong. They were not going to create that kind of situation here in the United States of America. They did not want to see an aristocracy develop. So you might say that on that level, the argument of the defendants is that even though the founders were really aristocracy developed and had just fought a revolution over that they did something really dumb, and they just left this loophole in Article 1, Section 5 that you can drive a truck through. That's not the case, because when you interpret the entire Constitution as a whole, and all of the things that it says that touch upon elections for Congress, it's pretty obvious that you cannot construe Article 1, Section 5 exclusive powers to apply to the situation right here, to a premature swearing in. One reason is, another part in Article 1 says that elections for the House of Representatives shall be every second year and shall be by the people. So by not allowing the election to finish, by not even having the votes finished, it can't really be considered to be by the people as a whole. So there's a textual commitment, as they say in the Constitution,